Okay, well, I'll get it kicked off. Welcome to the July 9th SRLJC meeting. As always, we kick it off with a public forum at the beginning of it. So I will read this, and then it should also be posted on there, as you can see right there. Today's SRLJC meeting will begin with a public comment for up to 15 minutes. As a reminder, there is a 3-minute limit per individual. Speakers should address the matters which are within the powers of the duties of the SRLJC. Speakers should also identify themselves and address the chair. Council members will not engage in dialogue with the speakers. If you'd like to comment and have not done so already, send a chat to the admin assistant. She will assign you a speaker number and announce when it's your opportunity to speak. So I will turn that 3-minute on right now and give folks an opportunity. Medea, do we have anybody in queue at this point?
We do not.
Okay, we'll give it a few more minutes. Okay, Medea, do we have anyone that has sent email telephonically or otherwise asked to address the SRLJC at this point?
Not at this time.
Okay, then I will close the public meeting portion of the agenda, and I'll move to the minutes from May 14th, 2025. I'm looking for approval on the minutes. Do I have a motion to approve?
I'll move that we approve the minutes from the last meeting.
All right, I have a motion. Do I have a second?
Do we have a quorum?
I think there's 12. Well, let's see. We do not.
I think you're short, John. Mike, I think you're short a bit.
Yeah, I think then I'll retract that until we have others join. We can come back to that and revisit that portion of it. Thank you, John. I appreciate that. So let's just kind of go with some of the updates as we are we're talking here. Let's start off with Aaron Stromberger on a capstone update.
Yeah, thank you, Mike. We're still plugging ahead with supported release. Big thanks to Colin's office and the prosecutor and the district court bench. There's been a lot of good buy-in. We've seen our program grow quite a bit in the last 2 months. It's really taken off. We have 68 open cases right now in our supported release program. We actually saw a little dip in the number of people being held on bond the last 2 months and an increase in the supported releases. I don't know how that's related necessarily, but that's some good trends for the program. Had good, strong appearance rates for the folks who are actively engaged in the program. They're coming to court and they're staying arrest free, so that's good. Trying to see what other notes I had here. Anecdotally, we've just been gathering some good stories and good feedback from people involved in the program, and to the stat sheet I sent out to a lot of you, there's some good stories or good quotes in there you can read, but people are really liking the program. We're helping them even in their court dates. Kat, our mental health professional, sitting with them. Some of them benefit from, breathing exercises, just calming down while they're in court, and that's been a real plus that we've seen in the program. But yeah, the program's keeping us really busy. We also hired a second grant position to start making more court date reminder phone calls. Still kind of getting that person trained, but we're making some progress there, even starting in on the phone calls. So more to come on that. And then next week, we're going to interview for the court navigator position. We're hoping to put a information desk right there by the main entrance of the courthouse down by security. So security can point them to that person, and then that person can direct. Yeah, I know Tim's laughing at me, but that person can provide wayfinding assistance, walk people up to their courtroom, to the right department, etc. So we're going to interview next week for that and hopefully keep moving on that. So that's where we are. A lot of things going on with that capstone grant, but that's the lay of the land right now.
My office will love you for that, because
Okay.
security sends everybody to my office. It's hysterical.
Or pre-trial, we get a lot of people too.
Well, I think it's gonna be a huge benefit for everyone. It's gonna be nice to have that, in place, so. And then, the methodology that we got for getting the court navigator going through the schools, is that right? How did we attract the folks for that, Aaron?
I know HR had, I think they have I cannot remember the name of the program they have off the top of my head, but they helped post the job with the university's law students who are trying to kind of get some experience, or people just trying to get their foot in the door in county employment. So this is going to be, I'll back up a little bit. It's going to be more of a part-time extra help position, 25 to 30 hours a week. We're going to try and cover kind of the peak court times, help people get to their correct spots. But yeah, HR reached out to posted the job through the universities. And so we had, I would say, a lot more candidates than I'm used to seeing so quickly. I think 29 or 30 people. So we're sifting through all those still. Got some interviews lined up for next week, and we'll go from there.
Awesome, that sounds great. Tim?
Mhm.
Yeah, I think to answer, I think it's called the Skill Bridge program. One the county's using to bring people over for training.
It could be. I thought it was a
Future
different
jobs
name,
at the county, maybe.
but okay, that could be too.
Okay, super. And then on the community engagement front, we have two co-chairs. One is Dr. Velasquez and the other one is Judge Viviano out of district court. They've decided to chair it. We've had some meetings behind the scenes, getting ground rules established on that, and then also kind of giving purpose to it. The explanation that the community engagement part is an advisory board, and that they'll be providing information to the core group, the SRLJC, the MacArthur Foundation core group, and then making recommendations on moving forward and improving on community engagement. Our next meeting on that is July 24th at 6 p.m. and that one is going to be virtual. And then the meeting following that will be on August the 28th at 11 during the day. And that one is going to be in person at the MAC. So I know that if you're on that in the community engagement group, you'll get all the information sent to you along with the agenda. I just can't say enough. It's going very well. And I think that we're going to be, filling the lack of information that kind of dropped off with the last task force when Maggie had good momentum, going around the Justice Task Force, coming back, revisiting those as a jumping off point. Where do we end up on the last, conversations in the community engagement? I know that Dr. Velasquez and also Judge Viviano have got some recommendations of their own for how they're going to lead it and how they're going to guide the conversations. So I have a lot more to report out after the 24th, after they've, implemented some of those things. So far so good. So that covers, the supported release in the capstone, court navigator, pretrial services bump up, the community engagement part of it. And so for what was included in the capstone, those are the kind of the key elements of it. And then also being monitored by the MacArthur core group, which is going pretty fair. So next, I'll talk about the crisis relief and sobering center that we're building. We just finished up with the validation phase. We're entering to the schematic design phase of it right now, which is just super exciting. The project is going along well. So I think that as we get a little closer here, I'm going to be able to share some renderings of it or some conceptual pictures and drawings of it, which I think will be helpful for everyone to understand where it's located at, what it's going to look like. And then I know that Justin Johnson and I are gonna craft something that we can release out that everyone can use for like their constituents if they want to talk to it, and we'll have a copy of it. So it's still forthcoming on that one. But excited to move into the schematic phase, which is where we're at right now. I was gonna ask Colin Charbonneau if he could talk just a bit about the caseload standards, if you wouldn't mind, Colin.
Yeah, not a problem, Mike. So I don't think, other than Mike, probably any of you guys know this yet. I'll just give you a quick background, try not to take up too much of everybody's time. In 2013, the Washington State Supreme Court adopted caseload standards. It was based on data and anecdotal information from 1973. Didn't include all the stuff we have to deal with as defense attorneys, which is body cam, cell phone technology, DNA evidence. None of that existed in 1973. So things have changed. In addition to that, criminal laws become more complex. There are more statutes. There are more collateral or civil consequences to a criminal conviction. So there's been a study going on since about 2005 nationally, supported by the Rand Foundation. It finally was published in 2023 for anybody that wants to look at it. But it basically said what those of us who have been doing the work for a long time already knew. We've simply adopted a triage system, and the workloads are untenable. It's just not able to give everyone effective representation and maintain compliance with our rules of professional conduct. And essentially, it kind of says that, misdemeanors, for example, average, it's like 13.8 hours from start to finish of the misdemeanor case, like a DUI, for example. Well, if you extrapolate that based on number of hours worked and number of cases, et cetera, you get to some ridiculous number. It's not even possible to get anywhere near that given 400 misdemeanors, which is the current standard that we have. So that came out in 2023, that study. The Bar Association took that information, formed their own council on public defense, did a 2-year study with just Washington State. They didn't have as much data, but they did have a bunch of professionals, including prosecutors, judges, and defense attorneys involved. And they basically came out with guidelines. The Washington State Bar Association Board of Governors adopted those in March of 2024. They made in those guidelines some pretty strong recommendations, and some pretty strong language was used in the preamble and introduction to those guidelines as far as lawyers and their ethical compliance. About December of 2024, the Washington Defender Association started doing some CLEs for lawyers, right? Continuing legal education. Individuals in my office and around the state saw those CLEs. Some of the bar folks talked at those CLEs and essentially said that accepting cases at their current rate is likely unethical, that it wouldn't be per se violations of our code of ethics and the oath we took to uphold that, but it could be used as evidence against you. So based on that information, I've started in the last 2 months doing a deep dive, talking to everybody I could. That includes ethics experts around the state. It included the Bar Association themselves on multiple occasions. It's included the WDA, other directors around the state of Washington, and not everybody's on the same page, but after doing the research I'm convinced that the only way to ensure ethical compliance and therefore the constitutional right to effective representation is to implement the WSBA standards. To complicate things further, the Supreme Court came out with their own order on June 9th. It is not the same as the bar standards, and so there's been confusion. It's been fluid. Quite frankly, it still is. My understanding is the bar is going to come out with their formal ethics advisory opinion probably in September. Why wasn't it done before? That the current adoption of the bar guidelines, by the way, was July 2nd. Why wasn't it done before July 2nd? I don't know. I think this was poorly conceived by the bar and the Supreme Court, quite frankly, and put those of us on the front lines in the crosshairs and forcing us to make a decision that we didn't have all the information for. I'm currently in a position, though, that I have enough information where I'm convinced that it's an ethical obligation for me as a supervising attorney not to assign cases beyond the bar guidelines. And for those of you who don't know, they are less, it will be less cases handled by this office. And by the way, Counsel for Defense is on board with this as well. The city is doing their own thing, but as far as we're concerned in the county, that's what's going to happen, at least at the moment. Like I said, it's fluid. We could get information tomorrow or next week that changes things, or maybe in September with that advisory opinion. I don't know. But what it means, practically speaking, is substantially less cases being handled by this office. On the felony side, for example, it's now going to be case credits. The max for this first phase-in period is 110. Homicides are weighted at 7, life without the possibility of parole or third strike cases, but weighted at 8. And so a case is not just a case anymore, which of course, in my mind, makes perfect sense, because why would a shoplifting be given to an attorney and counted as one case, and a homicide is given to another attorney and counted as one case? It's utterly absurd. It's 300 hours on average to complete a homicide case, and 13.8, according to the study, to do a DUI. So it never made sense. It was based on antiquated information and numbers, but it's ongoing. And I think Mike wanted me just to give you a heads up. That's what's going on. It's changing constantly, but at the moment we are doing that. The judges don't know yet. Well, they've probably heard rumors it's the county, but pretty soon it's going to be Victoria and I in court saying we don't have anyone to assign to this case, or we're holding it for assignment. The similar situation happened in Yakima County. To convolute things even further, a judge in that scenario that I just mentioned actually ordered the King County Public Defender's Office to assign a case that was beyond the standards. And this is the other standards that we're talking about. And that case is currently before the Supreme Court. They've yet to hear oral argument, but it'll be interesting. The judge there basically said, yeah, you got to take the case. That's what it says by statute. And the public defense office says what I'm saying. No, the constitutional mandate is for effective representation, which means absolute 100% compliance with the RPCs. They're intertwined and they can't be separated for that. And so we'll see what happens there too. So Mike, did I miss anything that you wanted me to address there? That's as quick as I could make it.
It still sounds as complicated as it was when you explained it to me.
Yeah, for those of you, I had a meeting with Mike
Good
and
Lord.
county
Yeah.
commissioners, and yeah, it was a long meeting, and
Holy Moses.
yeah, there's a lot going on there.
Colin, you're so much appreciated for all you're doing on this, man. I know there's a lot going on. So
Thanks, Mike.
including managing your department on top of all of these things. So I can't say enough how much I appreciate it.
I appreciate that. Yeah, it's been a busy few months for sure. And then Aaron, maybe you and I can talk a little bit later too, because that's going to affect how you guys do things a little bit as well. And we'll work through we'll troubleshoot the problems we see.
Yeah, if you have 5 minutes after this meeting, I'll call you.
That'd be great.
Sure, thanks.
Kind of switch gears a little bit. Tim, could you mind talking about the Becca bill and the Becca bill reductions, please?
Oh, yeah, sure. Basically in a nutshell, Spokane County normally receives about 1.3 million in Becca funding. It covers us in juvenile court for caseload managers, for truancy, at-risk youth, and children in needs. And it also covers public defenders, and it covers the clerk's office. The state made a cut to the Becca funding, approximately 70% across the entire state budget. So Spokane County went from 1.3 million down to $425,000. And that's all we were given. That funding ended on the 30th of June. And anybody in a position funded by Becca, the county commissioners decided that since the state didn't think it was important, the county didn't have the financial wherewithal to pick it up. And so we were left with 425,000. The court made a decision to hang on to the 125,000 for court functions. And so what we had to do was, in our positions that we had people, we either had to laterally reassign them or release them and let them go. And so Colin had some folks, prosecutor had some folks. I had 2 people. I got lucky because I have one person that's going to law school. They are leaving this week. They will go, and then I will transfer the other Becca position into that position, but paid out of the general fund. So basically for the county, what you're kind of looking at is that we lead the state in truancy petition filings, which is what the Becca bill is designed for. It actually happened, I believe, in 1993, where Rebecca, and I can't remember her last name, was killed here in Spokane as a truant student that fell through the cracks and nobody was watching what was happening. And hence in 1995, they created the Becca bill to get the schools to notify when the schools have their own committee trying to work with students to get them back in school with the parents. If it is not working, then they come to the courts to get the authority of the courts to direct the students and parents to get back in school. And so the program is extremely beneficial for our students, but unfortunately, there's no funding now. So we're on a wait and see what's going to happen. The court is going to fund their functions to ensure that when truancy petitions come in, that we can address them. But we'll see how the schools are going to handle this with the cut in funding. Schools also got cut in funding too, so we don't know how they're going to respond. But that's where we are on Becca overall. It's pretty devastating to the program at the moment for the county. Colin, you've been at the meetings. Anything I missed?
No, Tim, I think it's going to be interesting. The only thing I think that I'll add is it's going to be interesting what the schools do is right, because I think there's a legal obligation for them to file petitions. So we'll see what their general counsel has to say about that. But otherwise, no, I think you covered it.
No, that's a great point Colin mentioned. It's a law. The schools are required to file these petitions, and we are required to accept them, file them, and act on them. We no longer have the personnel to do it. The Board of County Commissioners has been thoroughly briefed on this at multiple meetings, and so it's a conscious decision made.
Yeah, they got a lot coming at them right now, that's for sure. There's a lot going on from multiple departments. Judge Beggs, are you in a position where you could talk about the newly produced report? Or, oh, he stepped away. Oh, no, he is. There he is.
I'm back. Somebody knocked on my door.
Okay.
Yeah, I would love to. And then I think Mike's going to send it out if he hasn't already sent it out. But yeah, we just finished up. The Washington Association of Counties had sponsored the legislature to devote some money to doing a report on funding jails and more than just jails. So, repairing jails, building jails, correction officers, pay and benefits, and all the different kinds of issues, re-entry issues, all the kinds of stuff that this group looks at, but doesn't always have a lot of power on it. So it's a very broad group. It included jail administrators, prosecutors, public defenders, a couple judges, few legislators from around the state. And we just finished up our preliminary report that's pretty close to final, probably 90–95%. The final report's due in December. But anyway, I thought it was super helpful addressing all the issues that we do, even though it's on a statewide level. It just has interesting information, and the conversation was so robust, and we had lots of outside speakers, including people with lived experience and people who work in jails, and all different perspectives. So when you get a chance, I know everyone never has enough time to do anything, but I think it's pretty interesting reading and could inform us going forward as we, what the ask is essentially that the legislature give us a revolving loan fund at a very low level of interest, and then forgive even the loan payments if we invest money in data proven efforts to get people out of jail and rehabilitated in the community. So that's the ask of the legislature, but they may or may not fund it. But regardless, the strategies and the data and the science are useful. So I commend it to you once you get a copy of it.
Yep. Yeah, and then we'll get that out to everybody so they can all take a review of it. All right, shifting gears now, the SIMS model. I did meet with them again with Reggie and team, and we are on the final edits to the SIMS model report. There was some elements that I wanted added to it, which is the city SIMS. So it has more of a regional look at it. Where's the gaps? Is there overlaps in the gaps? Where can we identify some of those gaps? And then I've invited them to speak at the next SRLJC meeting and cover the SIMS priorities, and then go through all of those and itemize them out and address any questions that the panel has for them. So I think that's going to be hugely beneficial. Along with that, I'm inviting Judge Biviano and Dr. Velasquez to come talk about the community engagement portion of it. We'll have more information after we go to this next meeting, which is, like I said, is on the 24th of July. So I think it'd be beneficial to have those two as guest speakers for us to listen to and get some information on. So that kind of brings us down to, and I know there's a lot, we had a lot to cover today, down to you, John. And I think we're going to have to table your motion until we're able to act upon it. I think we're 2 board members short, right? You're on mute, John, I'm sorry.
I counted on the sheet, but Medea can, answer to this if whether or not we have a quorum. If we don't, then we're gonna have to table it, but I think there's 15 names on there and we have 8 people.
I see 13, John. And I think
I see
of
8.
of the members we have 1, 2, 3, 4, 5, 6, 7, 8, 9 of us.
Oh, I'm not sure. How many
think
do
we
we
need
need for a
12.
quorum?
I think we need 12 in order to have a quorum.
I thought it was 51%.
I can go back and count. Let me go see, right, let me go through the list. Why don't you? Yeah, see, we have 9 panelists, and then if we have 4 attendees, which are outside of it, John. So we don't have enough.
Oh,
Yeah,
okay.
yeah.
I didn't know we had attendees. Okay.
Anyway, why don't you just kind of give an overview, John, of what you want to bring up, and then we won't be able to take action on it today, but at least bring it up, please.
Well, I'll do a brief overview. You and I discussed it before we started the meeting a little bit, and my concern is that I brought it up last meeting, so I don't want to spend a lot of time on it, but we've had 15 appointments in a 3-month period for various boards and councils. And I have a concern that we do not have a racial equity board chairperson. And it's been a long time. I understand that the county commissioners have a lot of boards and councils to look at, and they need appointments as well. However, I would remind the commissioners that we have gone well over a year. It could be almost 2 years since we've had a person in that position. And so I kind of feel like we have a priority, but I think that probably every board and council feels the same way, that they want their appointments first. But the thing is I don't know how many of the other ones are under a county resolution, and we are. This position was under county resolution 21-0458. And so I just wanted to make a motion. I will move at the next meeting if we have a quorum. And I'll go ahead and read my motion right now. I can email it to Medea so that it can be put up for consider on the screen at our next meeting for the council's consideration. And I don't mind adjustments in my motion as well. I just want to get a person in that position, but my motion reads: the SRLJC urgently advises the Board of County Commissioners the need to add an upcoming agenda their consideration of applications for the racial equity chairperson position as directed in Spokane County Resolution 21-0458 regarding SRLJC bylaws. So it's in our bylaws that was approved by the commissioners by resolution. And so anyhow, that's the motion I intend to make when we finally have a quorum. I'm disappointed that we don't today. So that's all I have to say on that.
All right, thanks, John. And again, as I suggested earlier, I don't think that's a bad idea, that we try to give some visibility to the fact that we need to have that spot filled.
Mike, can I interrupt and just find out, have you heard anything recently, what their concern is, or why they haven't? So my understanding is there's applicants, they just need to choose one of them. So.
Yeah, I talked to the clerk, judge, before I came to the meeting, and she indicated that they're all under review, and ours is in a stack of probably 15, other board selections that have to be made by the board. I do know that CEO Simmons had brought it up at the last meeting that we need to have the board look through this folder and start looking through some of these appointments. And really, that's all I have to add to it right now, unfortunately. But I don't think it's bad for us to heighten the awareness of it, and I kind of like that idea. So that's all I have on that part of it, unfortunately.
Well, I just wanted to thank John for continuing to bring it up. So thank
Yes,
you for doing
yeah.
that. Please keep doing it.
Yeah, and I think all of us will echo that opinion. I think it's important, and I think it's something that we've got to certainly bring to the attention so that hopefully we get some momentum on that. So.
Yeah, Judge Biggs, before you got on, Mike and I were talking about it, and I did mention that most of us are here on this council by state law. It's an RCW. However, the county commissioners, in their wisdom, have allowed for 3 positions, and they don't have to do that. And so that is very much appreciated. And I know they're busy, and I just need to point that out each time it comes up, that it's because of their consideration of our community that we're even here. And so I appreciate that, and we'll bring it up at the next meeting and see where it goes.
Yeah,
Let me just amend one thing. You're totally right. It's not part of it, but they did not want to do it at the beginning. So it was public visibility and lobbying that got the position. So that wasn't their idea. And they, under pressure, added first one and then more. And those of us who've been doing this for a while realize what a great contribution it is to have non-statutory people. So, and this one's particularly painful not to have filled. So I do appreciate that they've expanded the vision of the SRLJC from the statute, but we can't rest. So.
Okay, I'm not going to let it go. That's for sure.
Yeah. Okay. This is the round table portion of it. So Dan from Risk Management, anything on the burner here for us?
No, sir.
Okay. Rochelle, I know that I got an email from you, but do you have anything?
I don't, since we don't have a race equity chair, we've just really have not convened. Yeah, and wasn't sure what to do with next steps. So please, for other committees, as the victim services rep, please let me know if or when I can join or provide input, and here to do so. I also have on an unrelated note meetings with Commissioner Cooney and then Waldriff and Chris Jordan throughout the month of August, but I also let them know in those meeting requests that I'm part of this group and specifically plan to ask them directly why there's been such a delay in appointing a chair, especially when we're having people now, specifically for John and I, finding our emails and reaching out to us asking why is not a good look. So yes, I plan to ask that directly to all 3 of them as well, and we'll report back.
Good. Good. I know Justin is traveling back from vacation, being that's why he's not here today. So he sent us an email. So okay, well, anything else for the good of the cause here before I give you a half hour back of your day? Okay, seeing no hands, you guys have a very good weekend coming up, and we will see you at the next meeting.